might even be a fourth superseding indictment.
That is not happening, correct? Okay, I did see Mr. Hendron walk in, so I believe we are ready to call pages 3 through 10.
Oh, there he is. I couldn't see Mr. Rutledge.
Okay, so I'm going to call the entire case number is C371483. We have Mr. Brooks for the state, and do we have Mr. Ports as well?
No, Judge, we had a pre-trial.
Understood. Okay, so we're going to proceed with just Mr. Brooks. I'm going to call them individually at this time. Starting with page 3, Raven Queen C371483. I believe Mr. Langford is on.
I am, Your Honor.
Okay, thank you for being on with us. This is on for return of the third superseding indictment warrant and the initial arraignment on that third superseding indictment. Date. There was an issue in the filed warrant compared to the indictment. Did DC 30 alert you of that issue?
They did alert me, Judge. I sent in. Are we talking about the bail amount?
No. It looks like the first degree kidnapping count with use of a deadly weapon resulting in substantial bodily harm had a different NOC code in the warrant and the indictment.
Oh.
So it was 50056 and 50055. So in the warrant, it's 56. In the indictment, it's 55. I don't know if that matters, but I'm bringing it to your attention because DC 30 brought it to me.
Oh, okay.
What's the correct knock code?
I will find out what the correct knock code is. I hate to say it, but since we don't use those, I don't ever deal with them. It's usually a...
So it's mostly, you think it's a clerical issue?
Yeah. I mean, it's a prison or jail type term that they use as opposed to we use the statutes.
Okay.
I will find out whatever it is. If for purposes of today, you want to just strike the knock code because it is a back-end issue and at some point...
Any objection to doing that, Mr. Langford, as there's a disagreement as to what the correct knock code for first degree kidnapping is?
No, Your Honor.
Okay, we'll strike that at this time. Mr. Langford, regarding arraignment, what are we doing on this?
We're going to do a not guilty plea and waive speedy trial.
Who was the one who had originally invoked? Ms. Brown, are you still invoking?
I am.
And are you seeking to get a fresh 60, or you're seeking to maintain that 410 date?
We're seeking to keep the 410. We're also filing a motion to sever either today or tomorrow. Because I know everybody else wants to waive but my client.
Okay. Ms. Queen, did you get a chance to review the third superseding indictment in this case, charging you with conspiracy to commit home invasion, invasion of the home, grand larceny, attempt invasion of the home while in possession of a firearm, conspiracy to commit burglary, residential burglary while in possession of a firearm, robbery with use of a deadly weapon, attempt murder with use of a deadly weapon, battery with use of a deadly weapon resulting in substantial bodily harm, first-degree kidnapping with use of a deadly weapon resulting in substantial bodily harm, victim 60 years of age or older, first-degree kidnapping with use of a deadly weapon, robbery with use of a deadly weapon, victim 60 years of age or older, battery with use of a deadly weapon resulting in substantial bodily harm, victim 60 years of age or older, and attempt murder.
Yeah.
Do you waive a reading of that, meaning you don't need me to get into read the specifics to you in court today? Okay, I will waive a reading. How do you plead to those charges? I'll enter a not guilty plea then. I will note for the record that you do want to waive the speedy trial. However, I'm going to maintain the previously set trial date and calendar call of 4/3/23 calendar call and 4/10/23 jury trial date. Mr. Langford, you'll have 21 days from the filing of the final transcript to prepare any writs. Additionally, I'll order discovery and reciprocal discovery. Is there anything else you want to address?
Nothing. Oh, well, the bail here.
Okay, Mr. Brooks, can you make a record about what happened with bail?
Yes, Judge. And I told some of the defense attorneys, and I apologize, during the grand jury returns, and I haven't seen a transcript, so this is to my memory, I am telling Judge Weiss, there was just a hearing that Nick Ports, my co-counsel, had in DC2. Bails got adjusted, and they had a Valdez-Jimenez hearing for the various defendants. Please just leave it as is. So that's what I'm articulating to him. Nick is not in the office that I'm doing the grand jury returns from, so I don't have those numbers. So I'm saying just leave it as is, it's already been done. But I guess when I'm conveying leave it as is, don't touch it, he didn't know the results of the hearing and assumes that I'm saying leave it as is from a prior indictment return. And so it was my mistake in the context of I should have been more clear, but I can tell you that in no way was I attempting to say leave it as is to this predated amount. I was trying to say leave it as is whatever occurred. So
it was your intent to leave bail on all defendants as was set on 3/6/23 by me.
yes, I believe there's been a subsequent hearing as to one of the defendants, but yes, my intention was to leave it as Your Honor ruled after the hearings.
Okay, so this bail should be $750,000.
Yes, Judge.
Okay, that's what bail will be set to. If that's not what CCDC has, we had been in communication with CCDC to try to get it fixed as well, and I don't know if they ever did, but that's where it should stay. For her. Okay, is there anything else in Ms. Queen's matter that we have to address at this time?
Nothing from the defense, Your Honor.
And so is it just for purposes of page 2, line 16, that's the not code that we're striking at this point in time?
Yes.
Okay, and I have texted, if I get an actual not code, I will let you know. If not, I will just have the different things.
All right. Moving on to page 4 then, Antonio Washington, C371483-2. This is yours, Ms. Zheng.
That's correct, Your Honor.
What are we doing here?
With respect to this matter, we are entering a not guilty plea. He is charged in the same counts as the previous indictments, which would be counts 1 to 5 and then counts 11 through 20.
Okay. And so it's a not guilty plea. Is he waiving the reading?
Yes, we're waiving the reading.
And he wants to waive speedy trial.
We have to waive speedy trial. I filed a writ for him yesterday. The court signed the order.
Yes.
That's not due to be heard. I just got it back from the clerk's office while I was sitting here until April 5th. So as a result,
The trial won't be able to go forward.
correct.
I'm going to give that date and we'll address it at that time,
That's
okay?
fine.
All right. Mr. Washington is
He is
there.
Yes, ma'am.
Okay. Sir, did you get a chance to review the third superseding indictment in this case, charging you with conspiracy to commit home invasion, invasion of the home, grand larceny, attempt invasion of the home while in possession of a firearm, conspiracy to commit burglary, residential burglary while in possession of a firearm, first-degree kidnapping with use of a deadly weapon resulting in substantial bodily harm, victim 60 years of age or older, first-degree kidnapping with use of a deadly weapon, robbery with use of a deadly weapon, victim 60 years of age or older, robbery with use of a deadly weapon, battery with use of a deadly weapon resulting in substantial bodily harm, victim 60 years of age or older, and attempt murder.
Yes.
Do you waive a reading of that, meaning you don't need to read it aloud to you in court today?
Yes.
How do you plead to those charges?
Not guilty.
I will enter a not guilty plea on your behalf. I will note for the record that you do intend to waive speedy trial. However, I will give you the same date as your co-defendants, which is a calendar call of 4/3/23 with a jury trial date of 4/10/23. Bail in this matter is supposed to be $600,000 with level 4 PCU. Correct?
That's correct.
Okay. Is there anything else in this matter except you did put on the record that the writ was filed? I did see that was filed. We'll have to address at calendar call the fact that we cannot go forward with the presently set trial in that matter, and we'll have to address Ms. Brown's matter regarding the severance. Okay, so that's it for this matter. Let's move on to Mr. Hendron's case. Co-defendant 3, Mr. Lee. What are we doing in this one, Mr. Hendron?
And Your Honor, this morning, Mr. Lee is going to plead not guilty to all the counts that he's charged with. In light of the fact of the most serious charges that were recently added, it's obviously changed our position of our posture for what we'd like to go with trial. It's been back and forth, but unfortunately, I think that's where they've now filed with that third superseding. So in light of that, we're going to need to waive. I mean, we're surprised it took this long for the state to get all this done. And then also my understanding as well is when we were at the court hearing our last court hearing addressing Mr. Lee's bail, there was mention that Mr. Ports had indicated there might even be a fourth superseding indictment.
That is not happening, correct?
I do not believe that's happening. I would say that it's extremely unlikely that that happens.
And just so everyone's on the same page, that would be a potential different co-defendant, not different charges, correct?
Correct. Co-defendant goes by Day. I can't remember the name. Day Shivine. I believe it's going to likely stay in juvenile and not be served up. That is what I'm hearing from a hearing that occurred earlier today.
Okay, so it's your intention to go forward with this third superseding
That is my
and not
intention.
go back to the grand jury on this?
Correct.
Understood. Okay,
And the reason I also asked that too, Judge, is because we were all waiting in order to file the pretrial writ of habeas until we knew when the last superseding was going to come to start.
and
the
of course your
timeframe.
time starts running once you get that final transcript, so,
We just want to know when the final one was, because otherwise we could, as you've seen the history of this, we would already miss the first indictment in light of, I think that's almost been past 21 days now.
sure.
So that was why I just wanted to make sure the state would
Okay.
confirm that.
All right, so we've got that on record. Turning to Mr. Lee, did you get a chance to review the third superseding indictment in this case? It charges you with conspiracy to commit home invasion, invasion of the home, grand larceny, attempt invasion of the home, invasion of the home while in possession of a firearm, conspiracy to commit burglary, residential burglary while in possession of a firearm, first degree kidnapping with use of a deadly weapon resulting in substantial bodily harm, victim 60 years of age or older, first degree kidnapping with use of a deadly weapon, robbery with use of a deadly weapon, victim 60 years of age or older, robbery with use of a deadly weapon, battery with use of a deadly weapon resulting in substantial bodily harm, victim 60 years of age or older, and attempt murder.
Yes, ma'am.
Do you waive a reading of that, meaning you don't need me to read the details of those charges aloud to you today?
I do.
How do you plead to those charges?
Not guilty.
I will enter a not guilty plea. At this time, I will note for the record that you intend to waive speedy trial. However, I'm going to give you this trial date, the calendar call, and jury trial date of 4/3/23 with a trial date of 4/10/23. Bail, which was previously set on 3/15/23, is the appropriate bail here, which is the $600,000 with level 4 PCU. And no, for all co-defendants, the condition of no contact with co-defendants as well as no contact with the victims does apply. And if I don't read it, that's just because I've gotten lost in all of the charges and everything, and I apologize, but for everyone that is going to apply. Anything further in this matter, Mr. Hendron?
No, Judge.
Okay. You have 21 days from today's date, from the filing of the final transcript, the third superseding transcript, to file any writs.
That's been filed already, just so your honor knows, so it would be 21 days
From today, then. Okay, sounds good. Thank you for letting me know that. And then you'll also do reciprocal discovery and reciprocal discovery pursuant to statute.
Thank you, Judge.
Ms. Brown is up. Page 6, C371483-4. Mr. Roberts' matter.
Good morning, Your Honor. Mary Brown, bar number 6947, on behalf of Derrick Lamont Roberts. He has received the third superseding indictment. We are only charged in count 6 through 12, to which he would plead not guilty, and he'd ask that his bail be reduced back to $250,000.
Okay. So it's a plea of not guilty. Will he waive the reading?
Yes,
And you intend to invoke?
yes.
Just want to make sure our minutes are correct because not everything has been, we haven't been able to keep up with everything. So ultimately, turning to Mr. Roberts, did you get a chance to review the third superseding indictment in this case?
Yes.
That one charges you with conspiracy to commit home invasion, invasion of the home while in possession of a firearm, conspiracy to commit burglary, residential burglary while in possession of a firearm, robbery with use of a deadly weapon, attempt murder with use of a deadly weapon, and battery with use of a deadly weapon resulting in substantial bodily harm. Do you waive a reading of that indictment, meaning you don't need me to read the specifics of those charges aloud today?
Yes.
How do you plead to those charges?
Not guilty.
All right, we'll enter that not guilty plea. You intend to invoke speedy trial. I will keep your speedy trial a 4/3/23 calendar call and a 4/10 jury trial. Your bail should be $250,000 with high-level electronic monitoring, no contact with victims or co-defendants, and discovery and reciprocal discovery pursuant to statute. You'll have 21 days from today's date for the filing of any writs.
Thank you.
Okay, anything else, Ms. Brown?
No, Your Honor.
Okay, moving on to Mr. Jackson's matter. This is C371483-5. Mr. Patrick, you are up.
Morning, Your Honor.
Not guilty plea?
Not guilty, Judge. He waives the reading. We've already waived. He waives again. And in fact, we actually have our motion to continue on Monday.
Okay.
Not only did the bail amount get confused with Mr. Jackson, there was some issues at house arrest with addresses of the two new co-defendants that have not been arrested and nobody knows where they're at. I talked to Ms. Bajas, and she was ready to have him released without those addresses, since there's no addresses to give, when the third superseding came out. So I would request that his bail be put back where it was, the OR house arrest, and hopefully now it's all taken care of and he can actually be
Okay.
released.
Let's arraign, and then we'll address those issues if there's anything outstanding. All right. Mr. Jackson, did you get a chance to review the third superseding indictment in this case, charging you with conspiracy to commit home invasion, invasion of the home while in possession of a firearm, conspiracy to commit burglary, residential burglary while in possession of a firearm, robbery with use of a deadly weapon, attempt murder with use of a deadly weapon, and battery with use of a deadly weapon resulting in substantial bodily harm? Do you waive a reading of that, meaning you don't need me to read you the specifics of those charges allowed in court today? How do you plead to those charges? I'll enter that not guilty plea on your behalf. For the record, you do intend to waive speedy trial. I'll put that on record. However, we're going to keep the calendar call and jury trial until we can address the motion to continue on Monday. I haven't figured out what I'm going to do with that issue. So give me some time. All right. So regarding bail, the bail so Judge Sachs set a bail. There was no additional information submitted to the grand jury, no additional charges, no additional information submitted in front of the grand jury, and so by law that had to transfer, and state it was your intent to transfer my decision in that case to this matter.
Yes, Judge, in this situation, when Judge Sachs set that at the lower level, given that there was no additional information, I don't believe that Your Honor could have done anything different. I don't believe the state could have actually asked for anything different. Again, I sent an apology to Ms. Brown when she alerted me to it, and I did send an email to all the parties. It was not my intention to somehow backdoor this raise. I was trying to be very clear, leave it as is.
Okay. So at this point, I'm going, bail should be for Mr. Jackson, an OR with high-level electronic monitoring. Additionally, he has to have no contact with his with any co-defendants and or victims. Any issues that you're working out with Ms. Bauhaus are between you. I'm not going to change that condition because I think it is appropriate, but I'll allow you to work that out in any way you can.
Very good, thank
Okay.
you, Your Honor.
All right, Mr. Jackson, you do need to be back for, if you're released, you need to be back for court on Monday to deal with the motion to continue, okay? We'll see you then. Mr. Rutledge, page 8, this is going to be Antwain McDuffie, C371483-6. What are we doing here?
It's the same charges to Mr. McDuffie.
So still maintain the not guilty plea?
Maintain the not guilty plea, waive the reading of the charges. We'd like to waive our right to speedy trial. I've started working on the trial, preparing for trial, and there's no way I'm going to do it. So I'm just letting the prosecutors know that come calendar call, there's zero chance that I'm going to be prepared. There's just way too much discovery.
Understood. Okay. We'll address bail after I arraign.
Yes.
Mr. McDuffie, did you get a chance to review the third superseding indictment indictment in this case? It charges you with conspiracy to commit home invasion, invasion of the home while in possession of a firearm, conspiracy to commit burglary, residential burglary while in possession of a firearm, robbery with use of a deadly weapon, attempt murder with use of a deadly weapon, battery with use of a deadly weapon resulting in substantial bodily harm, conspiracy to commit robbery, burglary of a motor vehicle while in possession of a deadly weapon, assault with a deadly weapon, grand larceny auto, and stop required on signal of a police officer. How do you plead to those charges? You have and it sounds like you also want to waive your right to a speedy trial, so we will enter that is waived, but I will give you the 4/3/23 calendar call and the 4/10 jury trial date. We'll figure that out as that approaches very quickly. Regarding bail, similar to the last defendant, this was OR with high-level electronic monitoring that should have transferred, correct?
Yes, I believe that's what was said by Judge Sachs. When there was a hearing, the state couldn't give you additional information because there were the same charges that were at the lower level. So at that point, state and your hands would have been tied, and so I'd ask you to go back to that setting.
Okay, so this bail should be OR with high-level electronic monitoring. He has to have no contact with any co-defendants, no contact with any victims.
Thank you.
Anything further?
No, nothing further.
Okay. I think that's it for anyone that we have attorneys on.
Well, sorry, while the attorneys are still here, I have the knock codes. We don't need to strike anything that's in the actual document. It must have been the warrant.
It was an error in the warrant, and so those have been addressed, so there's
Those
nothing
knock
that needs
codes
to
are
be
fine.
done there.
Yes.
So we won't strike the knock code on the indictment.
And Your Honor, if we could have my client put on calendar and brought over for Mr. Patrick's client's hearing, because they're going to affect each other, and I plan on filing my motion to sever today.
Okay, when we get that, I'll put it on for Monday.
Thank you.
I was also going to join in on the motion to continue, so I would assume if we can have Mr. Lee present, I was going to file that today, knowing that he's going to have that hearing on Monday.
File it, and we'll see when it gets filed, Mr. Hendron.
Get it.
Probably Monday. Okay, if you get it, the sooner you get it filed, everybody, the sooner I can actually put it that day.
Thank you, Your Honor.
I'll follow
Thank you.
Johnny.
Thank
So at this point, only you are on Monday, but expect company. Okay,
Very good, thank you, Your Honor.
Thank you.
page 9.